really excited to be talking with you today about New Orleans. New Orleans' criminal legal system has a reputation for lack of a better word, injustice. With the highest number of post-conviction exonerations in the country, New Orleans has earned the title of wrongful conviction capital of the world. Orleans public defenders have some of the highest caseloads in the country, along with the lowest funding, a fight that is ongoing. Life sentences for low-level felonies are common due to Louisiana's incredibly harsh sentencing laws. New Orleans' system of excessive fines and fees has been the subject of multiple lawsuits from civil rights organizations who accuse the jurisdiction of essentially criminalizing poverty. Advocates for justice reform say that New Orleans judges are part of this problem. But that may change soon. 5 current or former Orleans public defenders and an attorney with the publicly funded Louisiana Center for Children's Rights are running for judge right now. This election is the first time in New Orleans that so many public defenders are running for spots on the bench, which are usually filled by former prosecutors or private attorneys. One of these races pits Derwin Bunton, longtime head of the Orleans Public Defenders, against Rhonda Good Douglas, a 15-year prosecutor. In another race, Angel Harris, who, full disclosure, was my colleague at the Justice Collaborative, now a former staff attorney at the Orleans Public Defenders running for office, is challenging an incumbent judge, Franz Ziblick. Meg Garvey, another public defender, is running for municipal and traffic court judge, a position which reform advocates say is frequently overlooked as incredibly important. And she's running against longtime judge Paul Sens. And Steve Singer, former trial chief at Orleans Public Defenders, is running for magistrate judge against Juana Marine Lombard. If elected, these candidates would be the latest in a trend of former public defenders winning campaigns for judicial seats on a platform of progressive criminal justice reform. In the 2018 municipal elections in Harris County, Texas, Democratic challengers in Harris County ousted all sitting Republican judges up for election against a backdrop of longstanding campaigns and lawsuits to reform Harris County's cash bail system. Some of these challengers, such as Judge Franklin Bynum, were former public defenders running on a platform of prison abolition and major structural reform. A similar slate of public defenders ran a coordinated campaign for judicial positions in San Francisco. So now, as the wave comes to New Orleans, we are joined by 4 of these candidates to discuss their campaigns: Derwin Bunton, Angel Harris, Meg Garvey, and Steve Singer. Welcome to the show. Derwin, I would like to start with you. As the chief defender of Orleans Parish Defenders, you've been working for a decade to reform New Orleans' justice system. So tell us, why do you think running for judge is the best way to do that? And what are you hoping that you will be able to accomplish from the bench?
Well, first, Emily, thanks for having me on the briefing. This is really fun to be here with my colleagues and with you here to talk about this incredibly important wave that is hitting us this election cycle. And really, for me, it comes down to my history as an advocate, going now on 22 years in reforming these spaces that impact people, poor people of color in our criminal legal system. I started with juvenile justice reform, moved into public defense and criminal legal system reform. And when we look at how those movements have progressed, they've looked at sentencing changes, they've looked at police reform, they've looked at trying to make DAs more progressive. We've reformed public defense here in Louisiana from dysfunctional and unconstitutional to award-winning. And people have not really looked at the judicial space. Like what about what kinds of reforms have been aimed at the bench? And it was inspiring to me to see my colleagues jumping into these races. And it was incredibly powerful for me to think, hey, there's this other piece of this criminal legal system that we need to reform, that we need to see some change. And the best way, I thought, was the way I jumped into all of my reform, that is to get in and make changes. So I decided to run, to bring a spirit of innovation, hold power accountable, and bring back some just human dignity and respect into our criminal legal system. So that's really why I'm running, because of the opportunity that presented itself in all those other spaces presents itself now on the bench.
So let's talk about the perspective that you would have on the bench, because as you mentioned, you come from this long background of transformation and sort of defense side reform work. And I'm interested to have you sort of set out for us how being a public defender gives you a different perspective than a former prosecutor would have on the bench.
Well, I think for me in particular, I think I bring a fresh perspective on fair justice. And I think I can help in this moment as people are talking about this. I can be one of the catalysts to help redefine community safety and public safety. So I come from a background of standing proximate to folks most affected by the criminal legal system. I remember coming to Louisiana as a young attorney and sitting on, a concrete floor with a teenage boy who's naked across from me because they think it's too dangerous to give him clothes because he keeps trying to hurt himself. And I remember as I'm asking him about his life and his treatment, how did we get here? And I've been trying to reform these spaces ever since. And that's a very different mindset from folks who have been, for their career, applying the multiple bill statute and putting people in jail for stealing hedge clippers, trying to put them in jail for life for stealing hedge clippers, or decades because of marijuana they had on their person. It's a absolute different philosophy. And what really crystallized it for me as a young chief defender was watching a judge in the middle of a court proceeding where one of our lawyers is laying down a plea. It's a serious case. The client is 19 years old and he's taking a plea to 60 years. His mom starts crying and the judge tells her she needs to stop crying. And I understand keeping order in the court. But of course, she's his mother. She'll be dead before he gets out of jail. And ultimately, she has to ask her to leave. She's escorted. She doesn't provide any trouble or resistance. The deputy sort of walks beside her as she goes out. And as she hits the door, that judge says, "If you had done your job as a mother, we wouldn't be here." And I thought that was the cruelest thing I had ever seen someone with power do to someone in their lowest moment. I never forgot it, and I never forgave that judge. And it's been one of the things motivating me during this race.
Oh my goodness, I need a minute to recover from that story. I can see the perspective shift, and I want to come back and talk about the sort of perspective and stakes that you've just highlighted here in a second. Before we do, Angel, I want to bring in your background and experience because you've worked both as a public defender and as an advocate for criminal legal reform. And in the last 10 years, we've seen this major shift in public attitudes around mass incarceration and the sort of prison crisis in America. More and more people are favoring not putting people in prison, whether that's through an alternative to incarceration or through decriminalization of things. Public attitudes are shifting. And you've made these issues a centerpiece of your campaign. So I'd love to talk with you for just a second and hear why you think these ideas about ending mass incarceration and changing our justice system have become more popular over the last 10 years.
So, Emily, I think people are just tired. People are tired of being dehumanized. People are tired of, their communities being torn apart by our criminal court system, by a system that's supposed to keep us safe, by a system that's supposed to create healthier environments. And so, I also think the advent of social media and the popularity of social media has revealed or pulled the curtain back on what's really going on in courtrooms, because oftentimes the general public, they don't know what's going on in the courtroom. They just hear, oh, they're criminals and they have their assumptions around what that means and what's going on in the courthouse. But I think when you have organizations like in New Orleans, Court Watch, where they have volunteers who are in the courtroom taking notes and really exposing what's going on in the courtroom, people are appalled. People are appalled that individuals are facing life sentences for minor offenses because of prior convictions that they had. People are appalled that people are sitting in prison simply because they cannot afford to pay their bail. So we're talking pretrial, and people, the only reason why they're sitting there is because they can't pay a bail, not because they are a danger to society. And I think it shocks people's conscience when they actually hear about what's going on. And they're saying, not in my name, we won't do it anymore in our name. And, with all of the movements that are going on, I think people feel empowered, as they should. And I think that for me is why I decided to enter into the race. As you mentioned, my entire platform is about reimagining our criminal court system, reimagining a system that's rooted in rehabilitation and not mass incarceration. Mass incarceration is not the answer. And we've seen that. We've seen that in over a decade, we're still hearing the same statistics. We're still hearing that Louisiana is the incarceration capital of the world. We're still hearing that New Orleans leads the nation in wrongful convictions. Why is that? So why not try something new? Why not give everyone equal access to justice? Why not provide alternatives to incarceration? Why not stop the criminalization of poverty? And I think people are really excited about asking those questions and holding elected officials accountable. And I'm happy to be one of the people that's going to really just disrupt the system. And it's not business as usual anymore. And, with COVID-19, I think that also exposed some of the limitations or the harsh realities of our criminal court system. We saw through COVID-19 that there were individuals who were sitting in jail who shouldn't have been sitting in jail. And we know that they shouldn't because they were released. They were a part of a wave of people who were released from prison because they were not serving there was no purpose for them to still be in jail. And so I think when people see that, that's what sparked this movement. And I'm very proud to be a part of it. And, we talk a lot about the new normal. And, when we say that, we're saying it in sort of a negative tone when we're talking about COVID-19. But I think that we will have a new normal in our criminal court system, and that it's time for us to really push all elected officials to create a system that is just for everyone that's involved.
So, Adriel, when you say, why not create equal access to justice? Worst case scenario, we've built a better world. That's very persuasive. But at the same time as we've seen this momentum for reform, we've also seen a backlash from opponents who say that ending mass incarceration and letting all these people out causes a public safety risk. So what has that opposition looked like in New Orleans, and what's the history motivating that opposition? How do you respond to it?
So quite frankly, what it is it's fear mongering. That's what's happening. Anytime there's a conversation about ending mass incarceration, we start hearing about, oh, well, if you open the doors of the jail, we're going to be releasing all of these people into society. And, there's going to be a spike in crime. There's going to be a spike in violent occurrences. And if you've mentioned at the beginning of the show that there have been places that have changed the bench or flipped the bench in California, in Texas, and we're not seeing increases in crime. We're not seeing increases in violent offenses that are occurring, and really and that's the sad part, is that they're using fear tactics in order to keep things the way that they are. And, there have been challenges to bail reform. There have been challenges on the ground, just any efforts that have been made. One of the things they talk about is money. Where is the money coming from? But what people don't talk about is how much it actually costs to keep someone incarcerated. And so for me, I think what we really have to think about and what we really need to consider is the root causes of what's bringing people to the criminal court system. If we deal with the root causes, if we deal with mental health, if we deal with drug addiction, if we deal with trauma, then we don't have to worry about our criminal court system being a revolving door. We need to provide the services for individuals that are coming into court. And unless we deal with those court issues, then we're not going to have safer and healthier communities. So the conversation needs to shift to, what are the core issues? What's driving people to come into the criminal court system? Let's deal with that. And that's what I plan to do when I get on the bench.
Thank you so much for that, Angel. Meg, I want to talk with you for a second because you're running for a very particular seat. You are running for a court that primarily deals with traffic infractions and misdemeanors, which a lot of people say are sort of this dramatically overlooked but very, very important area of the criminal legal system, and perhaps a very important pressure point on the system. So tell us, how does this stuff, how does the little stuff fit into the bigger picture of ending mass incarceration?
Yeah, absolutely. 80% of cases in the United States are misdemeanors, right? So when we talk about criminal justice reform, if we skip over misdemeanors, we're not actually changing the way that the system affects the majority of people who come through it. Additionally, the way that misdemeanors work is sort of uniquely pernicious, right? Because there has been so many reforms. And it is true that there has been a lot of attempts to move away from jailing people outright for misdemeanors. And obviously that's commendable. But there are still ways that people end up going to jail for misdemeanors, right? People are assessed fines and fees. They're unable to pay those fines and fees. So they end up having their court dates reset. And then they still can't pay because the money's not just growing on a tree, right? And so then they have a new court date and they're still not able to pay. And so what happens is that it keeps building up to the point where they're scared to come back to court, and then they don't, and then they end up with a warrant. And then because you have a warrant, you can get arrested. And so in New Orleans, what we're talking about right now is that we have twice as many open cases in the municipal court as we have men, women, and children in this city. 88% of those cases is more than 4 years old. So we're talking about misdemeanors, right? And a misdemeanor has a 1-year statute of limitations. So why are these cases open 4 years later? Of those cases, over 2,000 of them are for the charge of begging. Begging was found unconstitutional by the Louisiana Supreme Court in 2013, yet those cases are still open. And even more terrifying, statistically, 1 in 7 New Orleanians currently has a warrant for their arrest from this court. And we see that Black people are 5 times as likely to be arrested on a warrant from that court as white people. So you see, just based on the numbers, that we have a terrible problem, that we have significant overreach by the court, that we have an unwillingness to take responsibility for what has gone on there. Now, our city council has had 2 hearings about this very issue, trying to get to the bottom of it. And in both of those hearings, nobody from the municipal court bench or the city attorney's office had any plan to try to resolve these issues. And quite frankly, there didn't seem to be a lot of concern about it. Nobody refuted the numbers. Nobody said that wasn't true. We're all in agreement on the numbers, but nobody has a plan to resolve it, except for me. And that's why, being a public defender, I love being a legislative advocate. I love the work that I do. But I felt that I had an obligation and a duty to jump in when I realized that nobody else was going to take this on.
Okay, so wait, let me stop you there, because this is the system you're describing. Twice as many cases as humans, and a fines and fees scheme that has been described as predatory by outside academic observers. What about the system? You said you've got a plan to fix it. What about the system are you going to fix?
Well, the backlog, right? Starting with that, right? And I'm not suggesting that I'm going to just like fix it, all in one day, right? But there are rules, right? There are obligations. There is a statute of limitations, or a prescriptive period, as we call it in Louisiana, to which the state is obligated to adhere, right? Additionally, prosecutors have a specific code of ethics that they're meant to follow. There are rules that specifically govern prosecutors and what is meant to guide their work, right? And it is meant to be seeking justice, not prosecuting at any cost. And so I definitely plan to get these cases on the docket, and hold everybody's feet to the fire about what are we really doing here? Let's move forward. Let's go. It's not going to be fun. But I think, it's absolutely terrifying that we have a court that thinks so little of the citizens that it is meant to serve, that they are willing to let people go without access to their driver's licenses, right? Because your license can be suspended when you have a warrant, to put them in a position where they may have trouble getting work, and to have them be in a position where they are terrified of possible dangerous interaction with the police and being placed in our jail, or COVID is running rampant, that they are so unconcerned about the average New Orleanian that they're unwilling to do paperwork. I mean, that's really what it is, right? And so, a lot of judges talk about efficiency. I obviously have no intention of sacrificing anybody's due process rights for that goal. But in this case, right, when we're talking about misdemeanors, we have to prioritize what's really important. We're at I think 25% unemployment right now in New Orleans. So to just kind of keep playing these games and chasing people down here and there for $10, $5, however much we can squeeze out of them, it's ridiculous. And it's not serving the larger community, let alone the people and the families that are coming through the system.
Thank you so much for that explanation. Steve, I want to turn to you for a second to talk about judicial campaigns. So a judge is by definition supposed to be a neutral party making decisions. However, in practice, we see elected judges often campaigning on being, quote unquote, tough on crime. And most judges come from a prosecution background, as we've heard, rather than a defense background. And many public defenders often experience this feeling that the bench is very, very pro-prosecution, rather than being that neutral arbiter that we are told a judge is supposed to be. So is that something you've observed in your practice? And what's your opinion on this?
Yes, it is something that I've observed over the 30 years I've been in criminal justice. I've been in public defender since 1989, and it's certainly something I've seen. And it's even more pronounced and even worse than people think it is, and that you've portrayed in the specific race that I'm running in, which is for magistrate court. Because in magistrate court, one of the main thing that magistrates do is set bail. The bondsmen for decades have controlled who is the magistrate judge through campaign contributions, through their money. The idea that the bail bondsmen get to pick who the magistrate judge is so that they can be sure that the magistrate judge will set bail bonds that keep them, the bondsmen, in business is a complete conflict of interest. I don't see how that system can pass any sense of right and wrong or any sense of conflicts of interest. I've committed to not taking any money at all from either bail bondsmen or anyone even associated with the industry. My opponent is the candidate that's been put up by the bail bondsman. And the main reason bail bondsmen contribute, they're one of the largest contributors in Louisiana to judicial campaigns and to state legislators. And the reason they do that is to keep themselves in business. Because the thing that most people don't realize about bail bondsmen is they do not do anything for the system. Most people think you put up a money bail, and then as long as you show up for court for everything, you then get the money back. And so the money is providing an incentive for you to have to show up and for your family to make sure you show up so that they get the money back. That's not how it works with bail bondsmen. When you pay a bail bondsman, that 10 or 13%, it happens to be 13% here in New Orleans, but most places it's 10%. That money that poor people pay to the bail bondsman, they never get that back, even if they show up for every single court hearing and the case is dismissed. So it's an insane system. It makes no sense at all. So then you have to ask yourself, why does it exist? It exists because the bail bondsmen contribute money and make sure that their candidates are in judicial positions like the magistrate judge.
So let me ask you, okay, you're not taking any money from bail bondsmen. And how does this free you? What are you going to do differently than magistrate judges who have received significant contributions from the bail bonds community, I guess you can call it? What are you going to do differently?
Well, it's right at the top of my sign, and it's right at the top of my literature, and it's right at the top of my platform. I am going to end money bail in New Orleans. I am going to put an end to it. Now, a lot of people have questioned, well, how are you going to do that? You're only one person. Well, first of all, the way the criminal court works is that I don't get 1/12 of the cases. Every single case in New Orleans that comes into the state criminal court has to come through magistrate court for bail setting. So I get to see and get to touch every single case. And then the other part of it is, while there are some state statutes that require that some money bail be set, until the state legislature fixes that, if a person is not a danger to the community or a flight risk, I'm just going to set a nominal bond. I'll set a $1 bond. Now I'm going to use other conditions of release that I think that are non-monetary and non-financial, because what our money bail system, what it does is it just keeps poor people in jail because they're poor. Right now, 1 out of 3 people in the Orleans Parish Jail are there just because they're too poor to afford a money bail. And 4 out of 5 of those people are Black. And so you're basically talking about poor Black people being kept in jail just because they're poor. So I'm going to end that. We're going to use other non-monetary means of getting people to court by creating a real pretrial services program to help people, as Angel was talking about, with mental illness, substance dependency, and helping them make sure to get to court and address their problems outside of jail.
So I'd like to ask a question of all 3 of you. And Steve, since I have you here, we'll start with you, and then we'll go to Meg, Angel, and Derwin. People often ask people running for office, why are you running? But that is not my question for you, because you've all told me really clearly why you're running. I want to know why now, because we're seeing this sort of wave of public defenders running for office in a manner we have perhaps never seen before. Why do you think more public defenders are running now? And what is motivating you? What is the change you see yourself being able to make from the bench that is motivating you to choose this moment?
I think that there is a grouping of factors. I think undoubtedly one of the biggest factors is that criminal justice and criminal justice reform and the way our system treats poor people and treats people of color, particularly Black people in the system, has now become national news. It's on everybody's radar. So that's the number one biggest point. The other factor that I think is really big, and I think is big for all of us, is that after Katrina, I worked with Derwin and Meg and to reform the public defender's office here. It went from being, as Derwin said, one of the worst public defender's offices in the country to an award-winning model public defender's office and model for change. And what we're seeing now is the maturing of that system. And I think what we've all seen from working in the public defender's office is pre-reform, pre-Katrina, we used to, all of us used to yell and scream about the poor quality of the public defender's office to very little effect. Then all of a sudden we got in there and we found, wow, we're in here now, we can really make change. And now you see, as Derwin's laid out, the results of those changes. So I think now we're all seeing, if we, instead of complaining and yelling about the injustice in the court system and the systemic racism in it, and complaining about it from the outside, if we get in on the inside, we can then now make change happen.
Exciting stuff. Meg, how about you?
Sorry about that. Yeah, so for me, I think it's about really, for me particularly, it really was about these hearings with the municipal court. So it really was about specifically, uniquely local matter. But I think it's also just about this sort of reckoning kind of thing that's happening across the country, where people are being forced to take action, and people are being asked, especially white people are being asked to be anti-racist, right? So it's not enough to say, oh, I'm not racist, right? But when you are presiding over a court system that is racist is as racist does, I guess I would say, right? And so while a person may not have, full hatred and bigotry in their heart, if they're not taking distinct action to try to make sure that their actions are not perpetuating white supremacy, and if especially if that person is an elected official that has the power. I mean, judges have a lot of power, even in municipal court, right? You hold somebody's fate in your hand, right? So if you're not actively trying to explore ways to look at that system and be very careful about what are the racial disparities and how are my decisions perpetuating it, you are part of the problem. And so I think everybody is starting to recognize that. And I think there's a lot of momentum towards that. And I think that there's a lot of support for doing that. But I also think, and this is a little scary, but I embrace it, and I think my colleagues do too, is that because I have been a public defender, because I have been a legislative advocate for social justice issues, and because I have been involved in so many community efforts to try to undo a lot of these injustices, all eyes are going to be on me. I'm going to be held to an extremely high standard. People are going to be coming back and being like, what are you doing? What's happening? Right? And I welcome that. I know that people are going to be very critical of my work and making sure that I do everything that I have pledged to do. And I welcome that because judges need to be held accountable by their community. And I'm excited that the community is stepping up to do that.
Inviting scrutiny, dangerous move, bold.
I've been a public defender for 15 years, so I'm not scared.
All right, Angel, how about you?
I think for me, it's really just sitting back and evaluating, my career. As you stated, I did direct representation. I've also pushed for policy changes, in my role at the Justice Collaborative and at the NAACP Legal Defense and Educational Fund. And I think for me, it was just, I'm tired of asking for the reforms. And so as a judge, I can be a direct actor, and I can do and implement the ideas and the methods that I've seen work in other jurisdictions. And so that's why, for me, why I'm running. And I think that's why a lot of public defenders, throughout our country, they're finally saying, we're tired of begging and asking for these things. We're tired of begging and asking for common decency in the courtroom. And so that's why for me, and I think it's even more personal for me as a Black woman, because when I look at who my clients are, when I look at who's being impacted the most in our criminal court system, it's people who look like me. And I hope that I also can be an inspiration for young Black women who are in law school or thinking about going law school, and not being afraid to step up and not being afraid to challenge an incumbent, because people, ask why are you doing that? And so I really just am riding the wave in the backs of so many other, courageous Black women who have fought and challenged the system. And I hope that, my ancestors guide me through this process.
Angel, that's such a lovely framework. Thank you for that. Erwin, we're going to give you the final word. Why are public defenders running now, and why do they want to change the system from the inside instead of fighting it from the outside?
Well, if I'm the last word, I'm going to say thank you ahead of time for allowing me to be a part of this. And I will say, first, I will adopt everything that my colleagues on this panel have said to begin with. And for me as well, it was a moment, Steve and I are the old heads on this panel. And for me, I had to confront the question of, is this a movement or is this a moment? Because we've all been here where Black man killed at hands of the state, everybody riots, maybe some stuff burns down, they announce the next commission, we move on, wash, rinse, and repeat. And I think I've simply allowed myself to believe that this is a movement, that this is a time where we can get in and have an opportunity for real change. This is personal to me. I remember I don't walk through stores with my hands in my pockets. And I don't do that because as a little boy, I put my hands in my pockets in the grocery store. My mom struck me across the back and told me, get your hands out of your pockets. You're a young Black boy. People will think you're stealing. And to this day, I cannot walk through a store and put hands in my pockets. This is a system that has made people like me grow up like that. And we have to understand and operate differently. And so in this moment, for this movement, I think there's a bunch of us who understand that, acknowledge that, and have said enough is enough. And we're getting in, we're going to take our turn at the table to make change and try and bring about a transformation of a system that for the last 100 or more years, for a lot of us, has not been able to get it right. And so that's why I think you see a lot of public defenders, because we stand most proximate to folks most affected by our criminal legal system. And we think that that fresh perspective to deliver fair justice is one that the community is ready for and that our communities actually need.
Thank you so much for that. I really appreciate hearing from you and all of you about your fresh perspectives in this race. Thank you so much for joining us. We are at the end of our show, but we will be back at 10:30 a.m. tomorrow talking about eviction laws in Philadelphia. So please join us then. This has been The Briefing, a co-production of Now This and The Appeal. I'm Emily Galvin Almanza. Thank you so much for joining us.